I'm Jeff Livesey. I'm the Associate Director for MiHIN, and we will have a long break right after this next presentation. So if you can hang in there with us. Go ahead. This is actually my favorite part of the annual conference. For 4 years now, Tim Pletcher has allowed me to introduce the most important people in the room. And if you've been here for a prior conference, you know what I'm about to say. But we have many luminaries here, from our keynotes to commissioners, from Governor Snyder's HIT Commission, MiHIN Board of Directors members, and other leaders from HIT from around the United States. But we consider the most important people for MiHIN's view of the world to be our interns, the MiHINterns. And the reason we consider them to be the most important people is because they represent our future. So if you're a MiHINtern, you're probably handing out white papers or standing over here. Would you please wave at the audience so they know who you are? We have interns in fields. Thank you. Thank you. Give it up for the interns. We have interns in fields from second-year law to Mandarin Chinese. We really don't care what their chosen field of study is, as long as they're willing to come in and work hard and learn and contribute, and they do. Sadly, from time to time, sadly for us, good for them, they graduate to go and pursue their dreams. Some stay with us. But the reason I'm telling you that is we do have full-time openings for interns every summer and throughout the school year. So if you know a young person who wants to have MiHIN on the resume, it's actually a good thing to have that work experience. So please contact Brandy Briones. Brandy, would you please wave? She runs our MiHINtern program, and she's always looking for talent. Thank you. So next, it is my great pleasure to introduce the next speaker, Chanley T. Howell, who is a partner at Foley & Lardner, LLP. He's an intellectual property lawyer, and his practice focuses on a very broad range of technology law matters. He is a member of the firm's technology transactions and outsourcing and privacy, security and information management practices, and the sports and healthcare industry teams. Chanley represents companies in a variety of technology law areas, such as data privacy and security compliance, software agreements, technology agreements, and internet agreements. And he's going to talk to you this morning about what your organizations should be thinking about from a legal perspective for sharing health information. Chanley?
Thank you, Jeff. It's a pleasure to be here. I am from Florida, and I got to say I like your weather. I'm from Jacksonville, Florida, and it's already in the 90s. So when I got up here and it was in the 60s and the low 70s, it was wonderful. And I thought about 6 months ago when I came up here with my partner, Steve Hilfinger, in the Detroit office. He's in the audience. And Steve and I went to meet with Jeff and Tim. And 6 months ago, think about it, it was snow everywhere, single digits, born and raised in Florida, went to college in Nashville, so it got a little cold there. Law school in Gainesville, so it was quite the shock. So when I came back 6 months later, a couple of days ago, it was very, very nice. And then Steve and I went to dinner, and he graciously gave me a walking tour of the Michigan State campus, which was nice because he is very much a Michigan fan, and we walked through the library, and he really wanted to yell, "Go Blue," but he restrained himself, and we made it back safely. So very, very appreciate the opportunity to be here today. As Jeff said, I'm going to talk a little bit today what you've heard from the two speakers, and you'll hear, and I looked at the agenda, as I'm sure you have, and I looked, and it's all about data sharing. You will hear all day about data sharing, and it is a wonderful, wonderful thing. You've heard it already from Nick and the Major General about what can be accomplished. You'll hear more. You'll hear about data analytics and so much can be accomplished. What I'm going to do is talk about some of the legal landmines. I know a lot of, you probably deal with lawyers, and it's a lot of no, no, no. I hope to tell you how to do things and at least point out some of the landmines and avoid them. So when you're using data in big data and sharing data, how to avoid getting in trouble, because there all are laws that you got to pay attention to. So I'll talk about some examples of big data. You'll hear, I think, a lot about that over the next few days, so I won't spend a lot of time on that. And mainly I'll talk about privacy and security. But just a minute about privacy and security, because the two terms, I think it's important to know whether you're compliance or senior management or staff. It's important to know the difference. And they're often lumped together. But privacy is more of a policy and decision about what we will keep private and confidential. And it's dictated in large part by the laws, but it's also a policy decision. Organizations can make decisions about how private they will be or how liberal they will be with sharing data. That's different than security. Security is the methods used to keep things private and confidential. And there's a saying, you can have security without privacy, but you cannot have privacy without security. And you may have heard that before or not. But to illustrate that, and what I want to talk about today is sort of the rules of the road so that you can, when you're dealing with big data, when you're dealing with sharing data, you can do it in a way that avoids getting in trouble legally. Yeah, thanks. So to me, it's like driving a car. The speed limit sort of sets the rule, and you make a decision whether or not you're going to abide by the speed limit. And you may go under it to be safe, you may go over it 5 or 10 miles, but that's a decision that you make. That's sort of like a privacy decision. How much are you going to share? And you're definitely dictated by the law. Then there's security, which is how you accomplish that goal. And in the driving analogy, it's the speedometer, it's the brake, it's you can look and see. If you're inclined to exceed the speed limit, you might have a radar detector. But these are all the mechanisms that you use to deal with your privacy decisions. So let's talk first about a few examples of big data in the healthcare arena. As you know, the information is coming from all different areas, comes from different providers. It's from patients, it's images, it's social media, it's Fitbits. That's really what makes a difference. And people say, well, what is big data? And what makes big data different from regular data is that it's coming from all sorts of sources, from all different places. And also the organizations using it are very varied. So you have payers, you have providers, and all sorts of different organizations using the data. So we see it in predictive analytics. That's like diagnosis and treatment. You will hear a lot today about how big data can be used to improve healthcare. Then there's customized medicine, and that's what the Major General talked about as far as looking to the individual. And there's the big data of what the trends are, and the small data as to what the individual needs. And what we're seeing is healthcare is really taking a lead from retail. Retailing has been using data to really implement their strategies for longer than healthcare has. Healthcare is lagging retail, but quickly catching up. So there's both the big data of what the trends are in predictive diagnosis, and also what is the health care that I need? And big data can use that to predict what I need. There's also predictive analytics for patient purchasing. And there's an interesting situation that I read about recently, and you may have seen it, on that using Twitter feeds. So social media is becoming, as you would expect, social media is getting into every part of our lives, and it's also into healthcare. But there's a report that has been published that using Twitter feeds, air quality data, and EMR records can drastically increase the predictability of how many people will visit a particular ER for breathing and asthma-related instances. And the interesting thing is it takes all these different sources and improves the ability to predict how many people will be visiting a particular ER. So you have, obviously the air quality data makes sense. But then the Twitter feeds search for words like asthma, inhaler, and wheezing, and then combines it with EMR records about zip codes, and it can predict what the demand will be on a particular ER department. So that's just another example of how big data is really transforming healthcare. And then I think you've all heard about, you'll hear about more, but the obvious waste and cost reduction, we've already heard about it from the two speakers so far, is a big point. Patient health self-monitoring, a very important part of the meaningful use. The government really wants, and we all want to know more about our health care and be able to monitor our health care. And personal fitness devices, the Internet of Things, the wearable devices, the Fitbits, just creating a tremendous amount of information that if that can be combined with your health, with your medical record, really, really changes the game. Uh-oh. Wrong button, sorry. This is just a slide that I think is interesting. This is for de-identified data, health data. Is it okay to share health information for research, and it's by age? No huge surprise, but I think it's important. It's interesting to talk about for a couple of minutes. As the respondents are younger, they're more willing to share. What this shows is it's a trend towards I'm okay sharing my information. You know, in the 65 plus, even though this is about de-identified data for research, 65 plus, not so much okay with that, but the younger folks are, and obviously that trend will continue. Let's talk a little bit about security breaches, because what I want to talk to you about is being able to use data and where you might get in trouble. And obviously one area is where there's a security breach. Well, if you're going to be able to protect against a security breach, you need to know where the problems are coming from. So this is from a very recent survey from Ponemon. I bet a lot of you have heard of him or may know Larry Ponemon, but very reputable in the industry. But these are useful in determining your strategy for data security. So it goes without saying, no surprise, there's been an increase in healthcare data breaches. What was surprising to the researchers and to the industry was that criminal attacks have increased over the last year, and since 2010 have increased 125%. So the difference is that there's been a migration from where 5 and 10 years ago, lost protected health information was on lost laptops and devices, and that was a very large source of breaches in losing information. It's now switched to intentional criminal acts purposefully targeting health information. I'll talk a little bit about that more. in a minute. But it's increased 125% since 2010. And then, as we all know, quote, everybody gets breached. It's not a matter of if, but a matter of when. Past 2 years, 91% of healthcare organizations reported at least one breach. 39% reported 2 to 5 breaches, 40% more than five breaches. 65% of healthcare organizations, that's covered entities, healthcare providers, health insurance plans, and 80% of business associations, business associates, vendors to healthcare providers, experienced electronic information-based incidents over the past 2 years. You know, just a huge number. Half of those were paper-based incidents, and 1/3, no incident response process was in place. So one message I want to deliver to you, and there's other things that companies aren't doing and organizations aren't doing that they should, you need to have an incident response plan and policy in place to mitigate the problems. So this is a breakdown of where the attacks are coming from. As I mentioned, criminal attacks have really, really expanded, and that's a problem because now it's intentional. People targeting you. It's not negligent employees leaving a laptop or losing a laptop, or even a bad person stealing a laptop. It's people around the globe, hackers around the globe trying to hack in. So criminal attacks account for 45%, the largest. Lost or stolen laptops and devices still high, 43%. Employee mistakes still high, 40%. And there's overlap in these categories. It's not, these don't add 100% because there's overlap. And malicious insiders is 12%. So you have to be diligent about the folks you hire and how you train them and supervise them. The impact. You know it costs a lot. The average economic impact, according to the Poneman survey just released, is over $2 million per organization. Also, a surprising finding, both to the researchers and to me, frankly, is the majority of healthcare organizations, and that's covered entities, fail to perform a risk assessment, even though that's required under HIPAA. There's ways to do risk assessments that are not overly cumbersome, don't break the bank, but need to be done, and they should be done, that are not being done, and that's part of the problem. Here's some more statistics. This is from Verizon. This is not healthcare specific, because I know we have business associates and vendors and people interested, not just from a hospital or physician, but this is just a breakdown. On the left side is what 2013, and on the right side is from 2004 to 2013, just real briefly. POS is point of sale. That's the card swipers. Web attacks, websites get attacked all the time because when you have customers and patients that can log in to their information, that means hackers, if they can get through, can access the patient information. Insider misuse, physical theft and loss, miscellaneous errors. Miscellaneous errors are things like administrators, that includes faxing information to the wrong place, includes uploading information to an unsecured website that shouldn't be. Crimeware, card skimmers, cyber espionage is state attacks. This slide shows how the volume of threat actions have varied over time from 2010 to 2014. As you can see, what I would point out on this slide is phishing at the bottom, the orange. Phishing is becoming a big problem, where there's emails and even telephone calls to get information that then can result in additional emails that coerce information out of individuals, and it happens more and more and more. Stolen credentials could be through phishing or through a weak website. But phishing is becoming a big problem, and that can be combated through training primarily. this is an interesting slide, still from the Verizon Report of 2015. One of the interesting things just shows is it doesn't really show a trend. If you look, it's sort of very all over the chart. And this is the frequency of incident classifications over time. And it shows you that the hackers go for the weak spots. So over time, they will find the soft spots in organizations. And so you can't focus on any one weakness or vulnerability. You have to look at all of these. And by the way, Verizon has been doing this report, and these 9 categories are really the 9 areas where your IT and security folks should be focusing, because these are the places where the hackers, it's not just the hackers, where the hackers and where the mistakes happen. As you can see, recently miscellaneous errors was very large, insider misuse was large, and crimeware, which is if you click on a wrong link, then you have malware or crimeware downloaded, and that sort of comes through phishing, as I mentioned before. All right, so as I mentioned, a lot of what you care about and what you'll be hearing about is sharing of information. So I want to talk a little bit about where the legal issues are when you are sharing protected health information, PHI. These are sort of the big bucket categories. There's others, but these are the big ones to think about and to consider when you're dealing with data. You know, psychotherapy notes, that's actually part of HIPAA, which is excluded. There's lots of gray areas on that, but it's basically when a psychotherapist or a mental health professional is sitting down in a session with a patient, taking notes, talking about history, talking about what the problems are, not so much what's your blood pressure, not medication. All those things are part of the medical record, but the mental impressions and the notes of the psychotherapist are treated separately and need authorization. So when I talk about authorization, in the HIPAA world, there's authorization and consent. In some circumstances, a patient can consent to releasing certain information just verbally. Where authorization is required, it requires a written document. It can be electronic, and I'll talk about that in a minute, but it requires a written document signed by the patient. So psychotherapy notes are one bucket. Using protected health information for marketing is another bucket. If you're going to be using that or sharing, it needs, and we'll talk about the nuances, it needs authorization. Sale is different than marketing. It's transferring the protected health information for some type of compensation. And then sensitive health information. You know, we've heard today already about substance abuse information, mental health. Other areas are genetics, HIV/AIDS, domestic violence. There's categories under federal law and then state law. There's all sorts of state laws protecting a lot of these areas of sensitive information, which require special authorization more than just HIPAA, which allows for treatment in business operations and for payment. So we'll run through very quickly on marketing. Marketing of protected health information is any communication. There's really 2 buckets I want to explain to you. The first bucket is if you're making a communication encouraging a consumer or a patient to purchase a product or a service, that's marketing. And it doesn't matter if there's any, HIPAA talks about remuneration, I call it compensation being paid, but if you're marketing to a patient, and I mean a covered entity, that's one bucket where authorization can be required. You know, so for example, a hospital that wants to inform former patients about a cardiac facility that's not part of the hospital, and it's not for treatment, the hospital can't do that because that's marketing a third-party cardiac facility. Can't do it. That's one way to use data and share data, but it can't be done. Similarly, a communication from a health insurance about a property and casualty product, because it's not related, it can't be done. So that's the first bucket, marketing a product or service that is sort of unrelated to the healthcare operations. The second bucket is providing protected health information to a third party for that third party to market its own products and services. And that's restricted as well. So for example, if a health plan wants to sell its customer list to a manufacturer of glucose monitors, it can't sell its customer list to that. That's marketing prohibited by HIPAA. Or if a drug manufacturer receives a list of patients in exchange for compensation to be able to market, that can't be done. What's not marketing, which I think is important to know, is if the provider, the covered entity, is marketing its own products and services. So for example, for a health care plan, information about benefits of the health care plan or products and services available through the health care plan that are only available to members can be done. Another example is a hospital wants to market its new specialty group, say orthopedic group, or a new equipment, new x-ray machine. If it's its own products and services, then the hospital can do that. It's not a violation. So and then also, if information is being shared for case management or care coordination, that can be done as well. So the closer it is to, the general concept is the closer it is to treatment is okay. But if it's trying to market a third-party product or service, or if it's being shared with a third party for marketing, that's the danger area. There are some exceptions. Refill reminders is an exception that's coded, written into HIPAA. So obtaining money for refill reminders is okay, but the compensation has to be related to the cost of providing that communication. Similarly, face-to-face communications are accepted. The sale of PHI, again, that's the transfer of protected health information that doesn't have marketing implications. That has to be authorized by the patient. Similarly, there are exceptions if you're being compensated for the cost of collecting and transferring the data, that's okay. Transferring PHI for treatment and payment is okay. M&As, mergers and acquisitions, that's an exception. Obviously, covered entities can share information with its business associates, disclose to patients. And important one here in the purple at the bottom, exchange of PHI through HIEs and health information networks. HIEs and HINs get paid for what they do, and that's okay under HIPAA. MiHIN does it, and that's appropriate. There's a good reason for that, and that's appropriate. I'm going to flip through here just to make sure we stay on time and get to some other points. I alluded to this, but just to keep in mind, and I think everybody knows this, federal law HIPAA sets the minimum standard. States can and have on very many occasions passed laws to make things more protective. That's what makes it difficult in this area of data sharing. But you got to look at not only the federal laws, but the state laws. There's also restrictions outside of HIPAA. FERPA is the federal educational rights law. The FTC deals with privacy policies and unfair and deceptive practices. And then contractual provisions. If you have contractual restrictions on sharing information, you need to be careful to comply with your contractual requirements. I want to talk now about electronic authorization. Because this is we're sort of changing gears here. So what I just talked about is when consent or authorization is required. Now is how do you get that? In the electronic world, it's very different than the paper world. The paper world, you get the clipboard, you get the papers, the patient signs, you put in the file. How does that translate to the electronic world? There's two aspects of electronic authentication. There's identity proofing and electronic authorization. In fact, what I did earlier today, and if you haven't done it, I suggest you do it, but MiHIN has an actual demo of getting an identity verification or identity proofing. And it's very, very cool. And I hadn't actually done it. And I told my partner Steve, it's like, I'm very glad I saw that because I know the law, but I've never gone step by step. And I was able to go through step by step to see, okay, if I'm a patient or if I'm a provider, here's how my identity is verified. And that goes all the way to an actual notary that will verify your identification. But the big picture is that there's 2 points to electronic authorization. That it's proving who you are, and then when you log on to a website, are you authorized to log into the website? And so there's levels of assurance. I don't want to get too much into the weeds, but I have this in the slides, and we can circulate the slides, but there's a NIST publication that deals with this. But the MiHIN, for example, the MiHIN process follows a level of assurance, level 3. There's 4 levels, 1, 2, 3, 4. 4 being the highest, 1 being the lowest, 3 being very, very strong. And 3 basically being a 2-factor authentication, and if you go through the process, you'll see that. The other challenge with electronic consent and authorization is data segmentation. That concept is, as I've talked about already, there are lots of different levels of sensitivity. There's your basic health information that can be used for treatment in business operations and payment. Then there's substance abuse, there's HIV/AIDS, there's domestic abuse, mental health. All have varying levels of sensitivity. So when I have a medical record, how do I give consent electronically to 1 or 2 or 3 of those, but not all? But that's one of the challenges. I looked at the agenda, and one of the things you'll be hearing about, which is a challenge, but fortunately being worked on. But why, the first 2 speakers is that we need to do more, and that's a big challenge to being able to do more. De-identification is what I call sort of the holy grail from a privacy and security lawyer. If you can truly de-identify your data, then it gets it outside the scope of HIPAA and every other privacy law, including in the EU. The catch there is truly de-identified. It's sort of like the Holy Grail. Does it really exist? Or it's like a unicorn. Especially in today's world, and you may have seen articles, if you have 3 data sets on a person which doesn't have a name or address or a credit card number, but you have these 7 other identifiers, can you re-identify the person? So that's a challenge. But I can tell you, de-identification, if it can truly be done and under HIPAA, there's 2 ways. The safe harbor, which is removing all of these certain elements, or an expert looking at the data and saying, yes, it's truly de-identified. But that is a way to share data without having to worry about the legal implications. So just to close in the last 5 minutes on sort of the way we view data security and things that you should be doing. It may be difficult to read. Now, we did we do have a white paper, and this came from our white paper. I think it's been distributed. If there's not enough copies, let me know. But a couple of points I wanted to talk about. First of all, very important. It's an evolving standard of care. And so what worked 3 years ago or 5 years ago for security in complying with law may not work today. The difficulty with the laws is they don't tell you exactly what to do, and that's a good thing. We don't want the laws to say exactly what we have to do for data security. So they're all very flexible. You know, every now and then you have a law that says you have to encrypt this if it's going here. But generally, it's not a lot of detail. So when we're talking to the security engineers, they say, well, legally, what do we have to do? And I can't point to a law and say, here's exactly what you have to do. It's got to be reasonable under the circumstances. So the point being, so these are just some examples. So password, biometric access, and encryption. You know, this is a general depiction from over the last 10 years. Not much happening in this area 10 years ago. Today, very, very prevalent, very important. If you're not encrypting data on mobile devices, on laptops, then it's not, in most instances, it's not unlawful. But if there's a breach, you're going to have a problem, and you should be doing it. The second line there is, these are examples. Bring your own device policy. You know, they didn't exist 10 years ago. Now everybody's bringing their own device, and so you need to have a policy to deal with these things. And you need to have security in place to deal with if I bring my personal device and I have all of my law firm emails on my phone and I lose my phone, what happens? Well, what should happen is that the law firm can get rid of those emails because there's a lot of sensitive data. The problem is I also have my personal, you know, emails and pictures and things on that phone. And so the industry is struggling with, you know, how do you segregate personal data from the business data? Offshore vendors is the next line. You know, it was very unregulated 10 years ago. Now, if you're using offshore vendors, there needs to be a significant amount of due diligence that goes into that. And if you're not following that, you're falling below the standard of care. There's no law that says that. It's just the industry is developed. Cyber security insurance is a good example. I'm not sure if there was any in 2005. 2015, I don't know what the market saturation is, maybe a third, depending on the industry. But it's more and more common, and that's not so much complying with law. That's more of what organizations should be doing to protect themselves. Because as information is moving to the cloud, you know, Amazon Web Services, for example, Microsoft, IBM, all have cloud services. And our job as a lawyer is to get contractual protections. It's very, very difficult. And they are not, the big vendors are not giving it. So what we then have to do is turn to the client and say, all right, well, then you need to get insurance. And also you need to be sure your vendors have insurance. Now, Amazon's going to have the resources to cover it, but when you're dealing with a smaller company, you need to be sure that both your organization and the vendor has cyber insurance, because the regular commercial general liability policies don't cover it. And then vendor security due diligence is a very important part that you've heard about, that making sure when you do business with vendors that they are reputable, that they have security in place. So the standard of care evolves. This, you may not be able to read, it's in the white paper, but we have action steps, you know, concrete things that we think companies should be doing. I'll just hit some of the highlights. You need to prioritize what security is. Policies are important. And then finally, this is in the white paper, so I won't go through in detail. But I know that policies are very important. We help clients with that. We worked with Jeff on that. They have a very robust suite of policies. And you can read about this in an amount of time, but I just wanted to point that out. So thank you for your time. I appreciate it.